this coming Monday, the 31st at 1 p.m. to address further scheduling. What I would ask the parties to do between now and then is to determine how long you think each side will need to present their sentencing remarks, whether you anticipate anyone speaking on your behalf. If so, how many, how long, so that I can then look at my calendar and adjust and make sure that I have the appropriate amount of time to do that. I'm not going to sentencing on Monday. It is just for further scheduling at 1 p.m. before my afternoon calendar.
Judge, would you be willing to consider persons appearing by Zoom for sentencing?
Yes, I would not do anything different than what I've been doing since we started utilizing Zoom, and that is to make it available for both victims and family members of the defendant if they so choose to make statements over Zoom.
Sorry I'm late.
You're welcome.
Way late.
All right. All right then. Thank you, everyone. We are adjourned for today. We'll see you all on Monday.
Man, I missed it all. See, it's only like 9 o'clock here. Yeah. So we can go back and watch. Let me see. How long? Let me see here. We can go back and check it out. But give me 1 second here. Hold on. And then we'll get rolling. Get rolling on here, Mr. Guilty Man. I don't think I missed much either. I mean, I knew what was going to happen. I mean, he was found guilty on everything, which is awesome. Excuse me. Excuse me. Jeez, man. I just woke up an hour ago. I don't know when I woke up. I commented on last night's stream to get attention. To get attention? No. All right. Let's see. Let me pop this. Pop out the chat. Get the overlay. God, I'm sorry for being late. I missed the live, dude. That sucks. That really does suck. Sorry, Debbie, I missed it. Thank you for the super chat. Give me 1 second. Debbie coming in hot right off the bat. What? Did you see the live from Sky News regarding Summer? No, I did not. I did not
Back
see
on the
that.
record in State versus Brooks, may I have the appearances,
I did
please?
not. Let's see.
Thank you. And sir, for your appearance this morning?
Why is he wearing that?
Apologize for that.
No, we don't have to go through the whole thing.
It's all right.
I like,
Ready?
Here is third-party intervener in that matter, appearing as authorized representative for my client. I'll set for value and return.
oh no, the little boy from the suitcase.
This matter to make my attention available for discharge of
terrible.
all obligations and charges connected with this case. I do not
But
dispute
did he
any of
shower?
the facts and the charging instruments, and make a reservation of all of my constitutional rights, mostly the First, the Sixth, and the 14th Amendments.
Thank you. The record to reflect that the individual known to this court as Darrell Brooks is present in custody in person. He is wearing his jail attire this morning.
For no good
I
reason.
do want to make a record that at 8:46 p.m. yesterday, I did swear in 2 additional sheriff's deputies who would be working with our jurors through the overnight or third shift hours. I did administer the same oath that was administered to all the other bailiffs yesterday evening. Then, of course, we are open, and the jurors are here, and they will be instructed to start their deliberations. The only other thing I would put on the record is I have received information regarding the Reddit post, that there was a subsequent post from that website indicating that it was a prank. And so I don't know to what extent the Sheriff's Department is looking into that as well, but it's my understanding, based on news reports, that that
So
post or site was taken.
basically what
Not the
happened
site,
yesterday
but it's no
after
longer, I
we
believe,
finished our
but there was that
4.5 hour live stream,
regarding
which was
that,
awesome,
from
by the
the
way.
administrator, I believe, of that post. So I just wanted to put that on the record.
I was going to go to bed
If and when, or I should
or
say
go to,
when,
sleep a little, and then I
investigation is completed,
didn't.
I will assure the parties that you will be provided with that information.
So I had like 4 hours of sleep.
Go
and
ahead.
then-
So it's being called a prank.
Per the Reddit post itself, yes.
So we.
I never,
That's a fact, though, right?
You're correct. I'm just putting on
Yeah, I
the
never
record
went
the
back to
additional
sleep.
information that's been reported on. And then again, once the sheriff's
So I just went
department
through the whole
concludes their
day.
investigation, it will be turned over to the parties. So at this point, until there's a question or a
Yeah, I do
verdict,
have the morning
the courtroom
voice
will
for
remain
sure.
Open. I'm going to be working in my office on other things, and will be available, of course, if there are any questions or if a verdict is reached. So notify the parties.
I just woke up
Yes.
like not that long ago.
No.
I could sing baritone right now if I wanted to. Oh, say, does that star
Chance to
spangled
fully
banner yet wave o'er the land of the free? I have a
It's
coffee,
very
thank you.
concerning.
Lulu, what's up? Thank you,
Whether
Lulu.
it's investigation, it's anytime there's
I have a
investigation,
coffee. I just got one.
judicial process
That's why I'm.
can compromise, especially
Duty, what's up?
seriously, which is why
Why's
I
my
turned it over
iPad not
to the sheriff's
turning on? It's just a mess. I'm just late. I'm late to the party. I'm late to the sentencing. I was late to the oh no, not the sentencing, but the.
look at some alternatives.
I was just late.
If I may bring up the
I'm sorry for being late. I hate that, dude.
in regards to
West Coast time sucks.
For the record, this did not come about from the prosecution side.
Pisses
from the
me
defensive
off.
Side, and certainly
God
not
dang
from the
it.
other side.
Shut up, Darrell. I'm
This is something
sick
that
of
just
your
pretty
crap
much sprang
already.
up.
Sick of your crap already,
A lot of my
Darrell.
concern, though, just not from just the language in the actual post, but
That is so many.
I was kind of concerned that I was
I
the
know,
last one
it
to learn of this
sucks.
information that had been known. I wasn't aware of it until after 6:30 last night, or around that time, because I don't want to misquote the record.
Dude,
but somewhere around
There's
that time.
there was no way, no friggin' way I thought that they were gonna come back that fast on 76 counts. It's just it defies logic. There's no reason that they were able to do it that fast. I mean, there is, because he's on video doing it, and I understand why. But I'm just ranting because it's 9:30 here on the West Coast, and they've already friggin' read everything off. Save some fun for the rest of us.
Specific requests.
God. Unbelievable. Unbelievable.
Look into a mistrial. And
How does this happen?
alternatives
I know. I'm sure they did. They
along those
did
lines, short
great.
That or along those lines, or a mistrial. I was looking at some. Obviously, yesterday was very, very long for everybody. And as you know, because of my status here in the jail, I'm allowed to have law library time up until a certain point of the evening, and then I have to shut it down per jail policy.
Oh, now you listen to policy?
So I was
You're a
able
dick.
to find a few different things that I wanted to bring to Your Honor's attention, if I may.
Go ahead.
One being United States versus Perez, 22 U.S. 579.
True Crime Utah. I got your email. I had woke up. I checked my email. Like one of the first things that I do.
Because that one is pretty old in itself, but it's referenced in a lot of the other.
And then I got a message from a few people, and I was like, oh, they're reading the verdict. I can't believe they're reading the verdict already.
Incorrectly, I apologize.
I really,
like the benchmark for what
I cannot believe it.
manifest necessity.
I mean, I can.
Kind of like one of the leading.
So don't get me wrong. Like, I certainly can.
In regards to issues similar to things like this when it comes into play,
When it comes into play.
and it specifically points to trial judge's discretion, and I think that's kind of like the leading one. Also, I looked at Brown versus Rushton.
Yeah, Rushton.
572 F.3D 198, which speaks to the language is basically it speaks to the same thing. It speaks about manifest necessity. It speaks about if there's an issue, exculpatory evidence, things of that nature.
Oh, there's an issue, all right.
Also, United States versus Bates. That's BATES. 917 F2D 388.
Bates. What could he be referring to?
And that speaks of potential for an impartial verdict. Specifically,
I mean, this
says
is the
that
last
if,
act of a desperate man, right? I mean, that's what this is.
along the lines
The
of
last act of a
impartial
desperate
verdict.
man.
If an impartial verdict can be reached, or
It
if a
can't.
verdict of conviction could be reached, but would
Yeah,
have
Reed's
to
Motel.
be reversed on appeal due to
Norman.
obvious procedural error in the trial. That's
The state of
main
Washington
issues that-
versus
that
Norman and
speaks
Norma
to.
Bates.
I also
That's what
looked
I'm
at,
talking about, Your Honor.
Arizona versus Washington, 434 U.S. 497, and that speaks to what I was stating before.
All
It
counts.
says, neither party in a case has a right to have his case decided by a jury, which may be tainted by bias, and I say that because it certainly wasn't anything dealing with the prosecution.
Does he throw any fits
They
and stuff
had
today?
Nothing to do with this. The
'Cause I like
defense
when
had
he does
nothing to do
that.
with this, and certainly you, Your Honor, had nothing to do with this. But
Oh, really?
just for the concern factor, the language,
The concern factor?
it's pretty clear that this, if not directly came from a juror who sits on this panel, it came from someone who sits in this courtroom every single day. The language, it directed towards
No
you, Your
fits,
Honor,
huh?
directed towards having clear bias towards the defense. Some of the things that they quoted of having knowledge of is extremely concerning.
No doubt.
Extremely concerning. And then going back to some of these,
It's rich that he's
laws
worried
that I
about
cited,
other
it talks
people's.
about,
It's rich that he's worried about other people's
something to the effect of,
behavior that's concerning.
the ends of public justice.
She wants to kill him.
But I think that
And
is
I don't
leaning
mean
more
that
so
like
towards the
hypothetically.
judge's
I really
discretion,
don't.
I would say, at least from how I was interpreting it. Obviously, I'm not educated in a lot of the laws in itself, but how I was interpreting it.
That's why you get a lawyer. Honestly, if he would have got a lawyer, he could have maybe got one or
This is
two of those
definitely-
charges
Definitely
thrown.
a concerning issue. Is definitely something that I would request Your Honor to take a long look at. Look at some options. Look at some alternatives. And those case laws I cited talks specifically about that, options that you, Your Honor, can look at and use your discretion to see if it's appropriate in any way. But I'm extremely concerned about this.
Are you?
If
So I went
anything,
back, and I do not
cautionary reasons,
I do not recommend
Your Honor,
this
you definitely
whatsoever. If you haven't seen
saying
the video of
case
what
laws and
he did, and I hadn't watched it fully.
Request though that you're making based upon the case law that you cite. I heard in there mistrial, but I want to make sure I understand your request for relief and what it is.
Hold on, I want to hear this. Sorry.
You say request for
Relief.
relief.
And what are you asking me to do based upon the information
A mistrial.
the limited information we have about the Reddit post? And this
It always goes back to Reddit. Reddit is a
I
cesspool.
guess my request would be, because of the concern of this, to look at a mistrial, or at the
He
very
cannot
least,
get the death penalty,
a
no.
discharge of the jury.
It's not
at
on the
this time.
table,
So
unfortunately.
this can be resolved.
Trust me.
This is alarming, to say the least.
Last act of a desperate man.
Post, and I don't know what Reddit is, to be honest. I've never heard of it or used it, so I don't know the extent of. It's almost like this could be like a snowball type of thing. It can start with something that's this small, and then it can snowball out of control into something totally different.
Yeah, we know what a
I don't know
snowball
the
is.
extent of this website.
Dummy.
I don't know who. Well, I think the name of the person who sent the who alerted the clerk, of course, to
Their name's Snowball.
To this post. I think his name is
His name's Snowball.
The email, but then that even begs the question of how did this person
I know.
come across this site? What is their significance
Nita, I'm like,
to this? What is their role in this? It's just so many questions, and I mean, clearly this points at the court's integrity. It points at your integrity, Your Honor.
You can find
alarming.
it on Twitter.
It's very alarming, and if there's a chance that there can be hidden bias in this jury, it needs to be addressed now rather than later.
Yeah, check it out.
This is very concerning.
No, I didn't. What's that?
Well, thank you for bringing up your concerns. Let me turn to the state.
Thank you for bringing up your concerns, but no one gives
And
a
other
damn.
issues they want to cover this morning.
Thank you for bringing up your concerns,
Jesse,
but you're a
original
piece of crap.
Was on a subreddit thread called Justice for Darrell. That's the copy that the defendant has in front of him.
Justice for
That post
Darrell?
was edited last night, claiming that it was a prank from the start and that the original poster was didn't think it would get that far out of hand.
Unreal.
The way that Reddit works, the only person who can modify the content of the original post is the original poster, and because the jurors have no access to any electronic devices, I think it's safe to say
I don't
that
think that Facebook will
our
have
12
it.
jurors back there are not the original poster.
Good
So, I
morning,
think that
Josh.
puts
Of all
that
the
issue
days,
pretty much
I know.
to bed. It's still obviously under investigation because
I
the
know.
court takes it so seriously, but there really is no
Messed up. Sorry.
actionable or any real reason why we should doubt
I'm
the jury's
bummed.
being unbiased in this case.
I object to that on the grounds, Your Honor, that
He's objecting.
like you just stated, it's an investigation going on. And if there's investigation, then that clearly says that something is amiss. We have 15.
Something's
We have
amiss.
15 jurors.
Yep.
There's still too many questions that we don't
Oh,
know.
yeah.
Too
Yes.
I don't think anything's put to bed because we don't know. It's unfair to say that the issue was put to bed when there's still so many questions left out there. I'm sure you reviewed it yourself, Your Honor. You see the language in this, whatever it is, thread. I don't know. I don't know what this is. It's clearly a post from somebody who has intimate knowledge of the trial and what's going on in the trial. I don't think. I mean, common sense would tell you that this is someone who's very close to the case. Whether they were intending to be funny, whether they were intending to try to prank the court or anything like that, we don't know. That could be anybody's guess.
Anyway, what I was gonna say was
The language in this, the way that it's formatted, they lay out 4 specific points of what they think.
what I was gonna say was
certain language in the case.
hadn't watched the whole video, like an unedited video, and
When we were in the room,
I felt like I needed to. I don't know why. It just drive my hate more,
they
and
specifically refer.
because like you kind of get caught up in the guy being a clown. Like he that's what he does. He's a clown. He's a
Plural.
child, and it's hard to take it serious. Him serious.
They say, and I have.
And so
I am biased against the defendant for the horrible acts he did. And
is that a young Burt Reynolds in the background?
Your Honor, they clearly attack you. This is
Hold on.
idea of fun. is anybody's guess, but I don't believe that it is.
Oh my God, it's Burt Reynolds.
By the way it's formatted and by the language.
My Lanta.
This is clearly someone with intimate knowledge of the case and what's going on.
That's Burt Reynolds.
Clearly. There's no other
To
way,
there's
Don
no other way to
DeLuise. Interpret this. You can tell by what they're laying.
Oh my God. Nah, the video's not on YouTube. Yeah, I've seen his rap video. It sucks.
I'm informed of the investigation, but there's still too many questions left in the air just from this. How can you say
I love that guy, whoever that guy is. He's the best. I want to be friends with that guy. I probably won't want to be friends with me, but I want to be friends with him.
What if it turns out
Not Darrell.
that more people are involved in it than just whoever this anonymous person was who left the post?
Mm-hmm.
It's too many questions and it's too concerning. What if something like this springs up again at the last minute? We've been going through the trial now for basically 3 weeks, the better
He's
part of
such a
3 weeks.
pile, dude.
And even in court dates leading up to the trial, we've never had anything like this happen. Nothing like this has been brought to your attention. Nothing like this has been brought before the court's attention. This just came out of the blue, and now all of a sudden it's being labeled a prank. Is that because they were found out?
Yes.
I mean, it begs so many questions. It's too uncertain. It's too concerning. And
Nobody likes you, Darrell.
it's too alarming.
You're dead.
It's too alarming to just overlook and say, "Oh well, we'll just set it to the side and let them." No, this.
Sorry, Sam.
There has to be some type of alternatives, and something has to be done. Something.
I
And
agree.
if that's a mistrial, if that's
Whoa.
discharging a jury, if that's some other type of alternatives that can be looked at, I'm sure that
Calm
case
down with the buzzwords.
options that could come into play. They deserve to at least be looked
He's
at.
so stupid, huh?
If
Yeah, he's
anything, to
stupid.
protect the integrity of the trial. I find it very hard to believe that this close.
Don't say don't say the
trial
M
being
word,
over,
my
and all
man.
of a sudden
Don't say any
these
apps and
issues are
stuff.
being raised.
The M word.
So this is obviously not a prank, and it's obvious that this is someone with intimate knowledge. It's very clear to me.
Yeah, me too.
Well, let me address your concerns, sir.
Uh-oh.
I cannot make conclusions at this point about whether this is legitimate or a prank. What I know is as follows. I received the information about the subreddit post at approximately 9:30, 9:40 yesterday morning. I and I alone made the decision to withhold advising the parties because of where we were at in the trial, because there was nothing in that post. It was an anonymous post that would lend credibility to that it was in fact one of these jurors. But out of an abundance of caution, I referred it to law enforcement because it is very serious if the integrity of these proceedings were to be put at issue by a juror. I'd remind you though, every single day these jurors were read the bulk of jury instruction 50. They all took an oath, and I have no reason to doubt that they would violate that oath at this time. So I took and I made the decision to withhold telling the parties because we were in the middle of instructing the jury. I was in the middle of instructing the jury, and I wasn't going to delay the proceedings because it was so speculative at that point and remains speculative at this point. As you know, the case went to the jury. I brought this up. I waited about a half an hour once the case went to the jury. Frankly, we had had a long day. I wanted to get a bit to eat, and then I wanted to come back out and make a record of what I had. Once again, the forensic unit with the Sheriff's Department has taken lead of this investigation. I'm not a part of that investigation.
It's
law enforcement.
what's he so
will
mad
handle
about? It says justice
From
for
my
Darrell Brooks.
perspective,
He got justice.
Not only did the clerk of court's office receive
That's justice, right?
emails regarding this, It sounds like the district attorney received emails. I may have even gotten one, I don't remember the time, it was later, regarding the post. Frankly, people figure out my email all the time. It was not solicited by me in any way, and I did not respond to it, and I simply forwarded that email on to law enforcement. So it's pretty clear to me that a lot of people have access to Reddit. I personally am not a user of Reddit, so I don't know the ins and outs of it, other than it is a social media site where people can create accounts.
It's not very social.
And post, and there can
It's
be
more
like chat rooms, for example, or just various, as this is called, subreddits. And at this point, you've requested a mistrial. You've requested that I discharge the jury. I'm declining to do that at this time, sir. Again, I need to make decisions based upon the record that's before me. And right now, the record is speculative. There are no facts.
None.
To support
No
a mistrial
facts.
or discharging the jury. I trust the parties will continue in their own independent investigations.
Right.
That you will continue reviewing case law, make whatever requests that you deem appropriate. I certainly will take time to look at the cases you have cited to see if there's anything
He needs a
based
flogging.
upon the requests that you have made that I would need to further review.
Wow.
But at this time, I do not see grounds for a mistrial. I do not see grounds to discharge the jury.
Let me see here.
And that is how I will address
It's
it at this point.
a muffin. So
I know the state, I believe, wanted to address something else. I'm not sure if that was it.
I know.
You had deferred to Mr. Brooks, so go ahead. Is there anything you want me to address or at least bring to the court's attention at this time?
Just a minor point, Your Honor. You had noted the defendant is in his orange jail uniform today. It's my understanding the jail did offer him the ability to put on his street clothes, and he declined, so I just wanted that on the record. There may be occasions where this jury has to be brought into the courtroom for one reason or another, and he should be in civilian clothes if that occurs, if he chooses to.
It's like she's trying to help
It's a good
him.
point to bring up. It is possible the jury would need to be brought out if there is any question that I need to answer on the record. If for some reason the technology were not to be working appropriately when videos or other evidence are displayed to them. And so it
Technology
is possible that
works
the jury would
every
need to
single
come out.
time.
Of course, they'll come out if and when a verdict is reached. So
We
I would
never have
certainly
problems
give you
with
the opportunity,
technology.
sir, if you want to
Not
change
here on the
into
lab, we
street
don't.
clothes, that I would certainly direct
We
the
never have
Sheriff's
problems with our
Department to make that
technology.
available for you,
Isn't
should you
that-
choose.
Isn't it my choice?
Yeah, it's
Yes,
your
it
choice.
is.
So why do I need to be in street clothes? Why does that need to be on the
You
record?
don't need to be.
That
Your choice should be placed on the record, sir.
if or
That's
if
why.
not, I was offered to be in street clothes. If I made it the choice,
Do you dispute that, sir?
yes, I dispute it because it's my choice.
Well, no.
At
Do
this
you
point-
dispute that you were
at this
given
point,
the
there's
choice
no-
this morning?
At this point, there's no reason why that should be on the record. That if I was not offered street clothes, what relevancy does that have to?
Could have potential relevancy later on if
Why?
you were to challenge that you and claim that you were required to wear your jail uniform or jail attire. You're
didn't-
not required.
I
This
didn't
is
make
a
that
trial.
request.
You have the right to wear street clothes, and I will certainly provide that opportunity should you wish to change.
What
at
does
any
the
point
L
in
on his
time.
shirt stand for?
But what you're telling me is it's your choice.
Tell me in the
to
chat
jail
what the
attire.
L
Respect that choice,
on his
of course.
shirt stands
So why
for.
does that need to be stated for the record?
I just
Why-
indicated why, sir. So,
I don't see the relevancy of it.
all right. At this
I
point,
never
unless there are
raised-
any further issues, I am going to go back into my office. The courtroom will remain open, and we'll let you know when the jury communicates
There-
with us, either about a question or verdicts.
There is something that needs to be addressed. Subject matter jurisdiction.
The
Why
court
hasn't-
declines that. I'm stepping off.
Why hasn't it been proven on the record yet?
Oh.
And I object.
I was going for wrong answers, but thanks for telling me that. I get it. It stands for large. I was kidding. It stands. I know. I mean, I get that. I get that part of it. All right. Did he go change? Like, does he come back? Left-handed. That's, see, now we're cooking. Lard mouth. Oh, rough. Loser. Locked up. I like locked up.
Record in State versus Brooks appearances are as they were before. I would make just one note that Mr. Brooks is now present in a suit. And I will also advise that at 9:43 a.m. this morning, I was advised that the jury had reached verdicts in this matter. And
she's like, let's get this the
without
hell
anything
over
further,
with.
I'll have
He's like, yeah, lame. It certainly is.
the jury brought out.
Your Honor, I don't consent to being called that name and would like to
lunatic. Skeeta coming in hot with the lunatic. Bam.
Your objections are noted. I will not be addressing subject matter jurisdiction.
Yeah.
Please bring the jury out.
Would it be proven for the record, Your Honor?
Just a reminder to everyone that I do expect everyone in the courtroom to demonstrate appropriate decorum and courtesy as the verdicts are read and refrain from audible responses. Any disruptions may result in removal from the courtroom.
Your Honor, is that a tacit agreement not to address subject matter jurisdiction for the record?
Jury's coming in. All rise, please.
I respectfully object to that ruling, Your Honor, and request the legal reconsideration of your ruling
Denied.
for the record.
Denied for
Your
the
requests
record.
are noted, sir. I will not be addressing that further.
For the record, may I respectfully reject that ruling and take exception to that ruling, Your Honor.
L stands for Lucifer. I like that. That's a good one. Liable.
Is that a tacit agreement in a
Lawless.
judicial determination
Good
that
one.
you don't have to answer that question as a public servant, Your Honor?
Lawful law.
For the record, may I request the legal or factual basis for your ruling, Your Honor?
It might have been a false alarm.
For the record, may I respectfully
Would be
request
jurist.
a written judicial finding of fact and conclusion of law on this issue, Your Honor?
All your requests are noted for the record. They all are denied, sir. All rise.
Every single
Jury's
one.
coming
Too.
in.
For the record, may I respectfully
Why does it stand for latex?
declaratory appeal on this matter, Your Honor?
Why? Why latex?
For the record, may I move to state
Hey, wrong answers only.
matter is adjudicated by a court of competent jurisdiction
The L stands for latex. Linda
based on
Lou.
what law or
Really?
fact, Your Honor?
That's a good one.
Is that a tacit agreement?
L stands
that
for
you don't have to answer that
latex.
question? For the record, Your Honor, as a public servant.
Your Honor, it's public.
You'll have to
It's
address
public
admiralty
matter.
law or
Public
common law
servant.
If this court is operating under admiralty law,
Will not be addressing any
Lumbo.
of those.
It's not limbo. It's lumbo, Mimi.
Thank you,
respectfully
everyone.
object,
Please
Your
be
Honor.
seated. Ladies and gentlemen of the jury, have you picked one among you to be the foreperson?
Wait.
All right.
Do they
I
cut
see
this
jury
stream
number
off, or-
11, degree recklessly endangering safety.
Oh wait. How fast does she read these? I can't. I can't listen to all 76, but I want to hear the murder ones. Unfortunately, because I kind of want my hair as long as hers. I like that lethal. She kind of is, right? I plead the fifth. It takes a while. I would think so. The fact that he was found guilty on every single count is amazing. Latex. She is kind of, yeah. Yeah. Well, what do you mean? Like she's pretty? Yeah, she's pretty. But she's a good judge, smart. My hair is not nearly... My hair is not nearly that long. Maybe one day. Whose hair is longer, me or the judges?
There are 76 signed verdicts and 76 unsigned verdicts.
76.
Would be what I would expect.
That's a lot.
Right,
My
I will
God.
read each
I mean,
one
honestly,
into the record.
are you telling me? I get it. Even working all night and discussing every single friggin' count. Even working all night, they came back with guilty on 76 counts, guilty on all of them. Before 9 o'clock on the West Coast. My God. I mean, I'm glad.
We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 1 of the information. Dated this 26th day of October
Look at his
2022, signed by the foreperson, juror number 11.
You're guilty, boy.
If you find the defendant guilty of first-degree intentional homicide, answer the following question, yes or no. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Answer, yes.
Yes.
We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 2 of the information. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Answer, yes.
Burn in hell, you piece of shit.
Hey, you are to be
Oh!
removed right now.
Oh!
Do not do that.
Oh! Oh!
We, the jury, find the defendant,
Oh,
Darrell E.
did anybody see the bailiff? Did anybody see the bailiff? I saw that. I noticed it, Mr. Bailiff. He agrees with the sentiment. Burn in hell. I agree. Let's hear that again. Oh, he looks at him like he's picking on me. You gonna let him talk to me?
Day of October 2022, signed by the foreperson, juror number 11. If you find the defendant guilty of first-degree intentional homicide, answer the following question, yes or no. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks,
Did I go back?
guilty of first-degree intentional homicide as charged in count 2 of the information. Did the defendant commit first-degree intentional homicide? Brooks, guilty.
Where is it? Please don't tell me I lost it. I lost it.
What I would expect. Weapon, answer, yes. We,
Where's
the
it?
jury, find the defendant,
Come on.
Darrell E. Brooks,
I
guilty
messed up.
of first-degree intentional homicide as first-degree Darrell E. Brooks.
Where is it? Come on, dude. Are you serious?
Be seated.
God. I got too excited.
That there are 76 signed verdicts. Brooks, guilty of first-degree intentional homicide as charged in count 2 of the information. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Answer, yes.
Burn in hell, you piece of shit.
Hey, you are to be removed right now. You will not do that. We, the jury, find the
He nodded.
first-degree intentional homicide as charged in count 2 of the information? Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Answer, yes.
Burn in hell, you piece of shit.
Hey, you are to be removed
You like how the bailiff didn't move one muscle. Nobody was.
right now. You will not do that.
Wow. Watch the bailiff.
We, the jury, find the defendant, Darrell E. Brooks, guilty.
I want you to burn in hell.
And I should state as to count 2, it was signed and dated a first-degree intentional homicide while using a dangerous weapon.
Watch him. Watch him.
Answer, yes.
Here, let's do this. We'll slow it down. You got to see it. Watch him.
Burn in hell, you piece of shit.
Hey, you are to be removed right now. You will not do that.
Watch him. Watch him.
We, the jury, find the defendant,
Oh, yeah.
Darrell E. Brooks, guilty of first-degree intentional homicide as charged
That's
in
what he
count
said.
3 of the information.
Look at that.
And I should state as to count 2, it was signed and dated by the foreperson, same as to count 3. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 4 of the information. Dated this 26th day of October 2022, signed by the foreperson.
Plant Love,
Did
you don't
the
have to call me a
defendant commit
dirtbag.
first-degree intentional
I'm sorry I was
homicide while
late.
using a dangerous weapon? Answer, yes.
It's not my fault.
We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 5 of the information, dated today's date and signed by the foreperson.
Yeah, it
Did
was.
the
It was
defendant
just
commit
like,
first-degree intentional homicide while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide.
The coffee's
charged in
strong
count
this
6
morning.
Of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree intentional homicide
yes.
while using a dangerous weapon?
Yes.
Answer, yes.
Yes.
We, the jury, find the defendant, Darrell E. Brooks,
I'm just
guilty
kidding, dude.
of
I know,
first-degree
I'm kidding.
recklessly endangering safety as charged in count 7 of the information, dated today's date and signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes.
I know. I'm just messing with you.
We, the jury, find the defendant, Darrell E. Brooks,
Keely!
guilty of first-degree recklessly endangering safety.
Biggest punishment
charged in
isn't
count
the
8 of the
punishment of
information.
life. It's realizing the
Dated
world doesn't
today's
revolve
date
around
and signed
him.
by the
It's a great
foreperson.
comment.
Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 9 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering
You
safety
tell him, Anna.
while using a dangerous weapon? Answer, yes.
Witchy woman. Thank you for your
Find the
email.
defendant,
And I
Darrell
did check it
Brooks,
out.
guilty
I'll talk
of
about that
first-degree
too.
recklessly endangering safety as charged in count 10 of the information, dated today's date and signed by the foreperson.
Yes, please be
Did the
careful.
defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 11 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 12 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon?
Yes.
Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering
guilty.
safety as charged in count 13 of the information, dated today's date, signed by the foreperson.
I don't know.
Did the defendant commit first
gross.
degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as
He
charged in
guilty.
count 14 of the information, dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while
Yeah.
using
Do
a
we need the
dangerous
box
weapon?
for it?
Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 15 of the information, dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first
I love
degree
pink.
recklessly endangering safety
Love
as
pink.
charged in count 16 of the information, dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes.
Where's that at?
We, the jury, find the defendant guilty. Defendant, Darrell E. Brooks, thank you. Juror number 19. Endangering safety as charged in count 56 of the information, dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell
A
E.
little
Brooks,
bit.
guilty of
How are
first
you?
degree recklessly endangering safety as charged in count 57 of the information, dated today's date and signed by the foreperson. Did the defendant commit Darrell E. Brooks guilty of first degree recklessly endangering safety as charged in count 63? I'm going to ask each defendant commit first degree recklessly endangering safety while using a dangerous weapon. Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety.
Where's all
charged
that
in count
crappy?
34
I
of the
mean,
information, dated today's
Th-
date.
he's
signed by the
pathetic now.
foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 35 of the information, dated today's date,
Of the last six,
signed by
okay.
the foreperson. Did the defendant charged in count 55 weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 61 of the information, dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon?
Hold on a second.
Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 62 of the information, dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 63 of the information,
All right.
dated today's date and signed by the foreperson. Did the defendant commit first degree
We're all a
recklessly
little late.
endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty
Yes.
of first degree recklessly endangering safety as charged in count 64 of the information, dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes.
He's already lost it.
We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 65 of the information.
Noel,
and signed by
the
the foreperson.
first.
Did the
Noel.
defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer,
Yes.
yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 66 of the information, dated today's date and signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell
I don't even know what count we're on, dude.
guilty of first-degree recklessly
Come
endangering
on.
safety as charged in count 67 of the information, dated today's date and signed by the foreperson.
This is the end, isn't it?
Did the defendant commit, for the record, I did have the alternates brought back in. Obviously, they did not deliberate, but it was, we, the jury, find the defendant, Darrell E. Brooks, guilty of hit and run as charged in count 73 of the information, dated today's date and signed by the foreperson. Did the accident involve death to Jackson Sparks? Answer, yes.
Here we
In
go.
count 70 of the information, using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 66 of the information, dated today's date and signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 67 of the information, dated today's date and signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of hit and run as charged in count 68 of the information. Did the accident involve death to Virginia Sorensen? Answer, yes. Dated today's date and signed by the foreperson. We, the jury, find the defendant, Darrell E. Brooks, guilty of hit and run as charged in count 69 of the information, dated today's date and signed by the foreperson. Did the accident involve death to Leanna Owen? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of hit and run as charged in count 70 of the information, dated today's date and signed by the foreperson. Did the accident involve death to Tamara Durand? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of hit and run as charged in count 71 of the information, dated today's date and signed by the foreperson. Did the accident involve death to Jane Kulik? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of hit and run as charged in count 72 of the information, dated today's date and signed by the foreperson. Did the accident involve death to Wilhelm Hospital? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of hit and run as charged in count 73 of the information, dated today's date and signed by the foreperson. Did the accident involve death to Jackson Sparks? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of bail jumping as charged in count 74 of the information.
It's
dated
2022.
today's date
He's
and
allowed.
signed by the foreperson. We, the jury, find the defendant, Darrell E. Brooks, guilty of bail jumping as charged in count 75 of the information, dated today's date and signed by the foreperson. We, the jury, find the defendant, Darrell E. Brooks, guilty of battery as charged in count 76 of the information, dated today's date and signed by the foreperson.
Although he's not going to have much of a choice in jail. The sleuthing Sandy in the house.
Mr. Brooks, would you like me to poll the jury?
Yes, Your Honor. I'm a little baby bitch.
Members of the jury, I'm going to ask each one of you individually to stand up.
Yeah, we saw it. It was
Identify
awesome.
your number for the record, and then state whether the verdicts read in open court are your true verdicts. I'll start with the foreperson. And I'll read your numbers first, so it's a little bit easier. So, juror number 11.
God, she made quick work of him this morning, huh?
Were
Judge.
the verdicts read in open court, or are the verdicts... Let me rephrase that. The verdicts read in open court, are those your true verdicts?
Yes.
Thank you. Juror number 3. The verdicts read in open court, are those your true verdicts? Yes.
I can.
Juror number
I'm also
6.
I'm making a box video too. That'll
The
be
verdicts
fun.
read in open court, are those your true verdicts?
It is.
Thank you. Juror number 14. The verdicts read in open court, are those your true verdicts?
Yes.
Thank you. Juror number 19. The verdict.
Anyway, so what I was saying was I watched the video of the accident.
The verdicts read,
Wasn't an accident, but you know
those your true verdicts.
what I meant.
Juror number.
What he did at that parade.
The verdicts read
He's
in
so
open
mad.
court, are those your true verdicts?
Look at that.
Thank you. Juror number.
Look at that face. He is pissed. Gonna claw somebody with those fingernails. And this dude, I was watching it. It's just the gnarliest thing you've ever seen. The attack, yeah, it was no accident. There was no accident about it. It was it's just I've never. There was one part of the video and Skeeta. Yeah, you can watch the video. Anyway, so there's one point when I was watching it and like the whole thing was absolutely like terrifying to watch, but there was like this little girl standing like facing the crowd and her parents, and he like zoomed right by her. He was probably like 5 feet from her. I mean, he flew right past her, didn't hit her, but I was just like, I turned it off. I had to, because I like that scared that. Just even seeing that was just like, that was towards the end, and I was like, okay, I'm done. I can't watch it. Because I really thought that she was going to get hit, and so many other people did. But I watched it because it kind of, you know, we kind of dehumanize him, which he said himself, which is his fault. He's the one that did that to himself. Nobody else did that to him. He can say whatever he wants. Nobody else did that except him. But for some reason, I was making fun of him so much. That finally I was like, well, maybe I should get grounded a little bit more. And I was like ready. I was like, time to go for the verdict. But I'm telling you, I had no idea that they would return 76 counts the next morning. I figured maybe at some point today, somewhere around, 2, maybe 3, even on like East Coast time, that would have been fantastic. That would have been awesome. And I missed the whole thing. I streamed. We streamed. We all streamed. I streamed. We all streamed for I streamed. For 4.5 hours. And I listened to the jury's instruction on what to do for 4.5 hours. And I missed it. Four and a half hours. Everybody else cut off. Everybody else left. Everybody else cut short. I stayed until he asked to wash his butt in the shower. And No, I didn't watch Dr. Mosell's video, but I will. Unbelievably, I have no idea how I missed it. I have no clue. But I did. 4.5 hours yesterday of this crazy horse crap. And I missed it. I missed it. Unbelievable. Good job, Josh. Yeah, exactly. And the jury nullification, the this, the that, like, come on. Give us a little heads up, a little warning. Not all of us live on the East Coast. Pew! Oh, man. Bummer. Well, that's the thing, I didn't even sleep in. I just, like, ugh. Bummed. Well, I appreciate that, Plant Love. I appreciate that. Darrell Brooks sucks. Yes, good job, jury. No, I know. Guilty on all counts. Finish playing what? There's nothing to finish playing.
Number 41. The verdicts read in open court, are those your true verdicts?
Yes.
Thank you. Juror number 45. The verdicts read in open court, are those your true verdicts?
Yes.
Thank you. Juror number 46. The verdicts read in open court, are those your true verdicts?
Yes.
Thank you. Juror number 48. The verdicts read in open court, are those your true verdicts?
They are, Your Honor.
Thank you. Juror number 51. The verdicts read in open court, are those your true verdicts?
Yes.
Thank you. I should state for the record, I did have the alternates brought back in. Obviously, they did not deliberate, but it was important to have them because there are certain instructions I give at the end. All right, Mr. Brooks, are you satisfied with the polling of the jurors?
No.
I'm sorry?
No.
The court is so satisfied with the polling of the jurors. The court now accepts the verdicts. Ladies and gentlemen, on
Lulu
behalf
Elring's
of
okay. He's
myself,
the
the citizens of Waukesha County, and both
Lucas
parties
from the
here,
show.
I want to thank you for the time and attention that you've spent on this case. Your
Yes.
service in this case is now concluded. There is no requirement that you maintain secrecy concerning what happened in the jury room, but you do not have to discuss the case with anyone or answer any questions about it. On behalf, again, of the court and all of the parties, we thank you for your service over the last 3.5 weeks. You are discharged and free to go. All rise for the jury, please.
I seriously can't believe that.
Thank you. Be seated. Anything from the state at this time?
Your Honor, the state moves for judgment on the verdict as to each and every count.
Anything from you, Mr. Brooks?
What is judgment?
Given the verdicts from the jury here today, the court will enter judgments of conviction based upon the verdicts on all 76 counts. Court will also revoke bond. In this case, I plan on bringing the case in Monday, this coming Monday, the 31st at 1 p.m. to address further scheduling. What I would ask the parties to do between now and then is to determine how long you think each side will need to present their sentencing remarks, whether you anticipate anyone speaking on your behalf. If so, how many, how long, so that I can then look at my calendar and adjust and make sure that I have the appropriate amount of time to do that. I'm not going to sentencing on Monday. It is just for further scheduling at 1 p.m. before my afternoon calendar.
Judge, would you be willing to consider persons appearing by Zoom for sentencing?
Yes, I would not do anything different than what I've been doing since we started utilizing Zoom, and that is to make it available for both victims and family members of the defendant if they so choose to make statements over Zoom.
Okay, thank you. That
You're welcome.
helps us in our planning.
All right. All right, then. Thank you, everyone. We are adjourned for
All
today. We'll
right.
see you all on Monday.
Sorry. I blew it. Love you guys.